You won't get in my house without a search warrant.
Oh, yeah, I will.
Seized the photos off the wall. They searched his closet. They searched the cabinets in here.
His phone was taken outside as he was caught recording, but he submitted the video and audio to local attorney John Bryan, who then put it up on YouTube. He said he handles lots of illegal search and seizure cases, but never one like this.
I don't know if I've ever really heard that my house was illegally searched by a judge. And the reason for that is because that's not what judges do. Judges do not search houses. Judges do not search anything. This is a case where a judge searched my client's home. The case went before the West Virginia Supreme Court of Appeals on issues of judicial discipline, and now the federal civil rights lawsuit is at the U.S. Fourth Circuit Court of Appeals on the issue of judicial immunity. I have some fantastic news about the case, but first let's recap what's happened so far. Imagine that you're sitting in family court as a litigant, and the judge looks at you and says, "What's your address? I'll meet you there in 10 minutes. I'm going to search your house with your ex-wife and my bailiff." March 4th, 2020, that's exactly what happened to my client. Here's what happened when everyone arrived at his house.
It's a laughing game for them. He said it's all laughs and fun for them.
Can we, hey guys, I need you off my property, please. Hey, you ain't allowed on my property. The only ones allowed right now is the judge and the deputy. Step off the property.
Yeah.
Step off the property. Judge, can I ask you something real quick before we get started? Judge, can I ask you something before we get started?
Sure.
Can you come here? I ain't trying to have everybody else listen.
Well, Mr. Luck gets to listen.
That's good. I'm asking you right now, I'm putting in a motion to recuse yourself because you're putting yourself in a witness capacity instead of a judiciary capacity. There's no search warrant. I need a list of everything that we're looking for.
You've got a list of everything that's worked for. It's attached
Not today.
to the order.
Not today. I don't know where some of it's at.
Well, we're going to find
you got
it.
it?
Your motion's denied. It's not timely filed.
I need a search warrant. You won't get in my house without a search warrant.
Oh, yeah, I will.
And on that order, ma'am, it says swing. These are two separate purchases.
You can't argue with me while I'm doing this, okay?
Sorry? Order's the order.
I'll have to think about that because that's pretty permanent in. That's not bolted down.
It is bolted down, all four legs. It is absolutely
It's
bolted
bolted
down. Yes, it is.
So I have to think about that.
Ma'am, step off. I don't need you in my land. Please go that way. Please go away.
She's entitled to be here. Now, you're either going to let me in that house or he's going to arrest you for direct. Are you recording this?
Yes, ma'am.
Take his phone. You're not allowed to record this.
Don't take my phone, sir.
Recording too. Turn off your phones. I'll take you to jail if you don't turn them off. Do you understand that?
The phone's not on, ma'am.
Why is she holding it? Yeah, why is she holding it? Put it up. Give him the phone or you're going to be arrested.
I can record on my land.
You cannot.
This is my land, ma'am.
I am the judge trying to effect equitable distribution.
Here.
We are having a hearing.
Okay. Go on.
Now, you let me in that house, but he is going to arrest you for being in direct contempt of court.
I don't think the phone's off, Your Honor. I think it's just in his pocket.
I just turned it off. Let's go.
Let
Come
the
on.
officer check your phone.
Control 160. Oh, it was on.
It was on.
No, my phone's not off. It was on. The recording's off.
Control.
Much later, during the discovery phase of the lawsuit, we were finally able to obtain a short video taken by the judge's bailiff showing a portion of the search that occurred inside my client's home. Here it is.
We didn't have to. You can have the other one. Take that one.
Here, go and take a look at
Just set it right there. We'll get everything when we leave. I'm happy to take my shoes off. Woo! Woo! That's cold.
Well, he's not.
Take them.
Again, I would never do it. My understanding was I sent it.
I understand what you're saying, understanding.
I sent it to her, Judge.
That is not what the order says.
Where can I send? Oh, there's the other picture.
Okay.
Control 130.
It's just like to order him to follow the rules, Judge.
Judge?
Hey, I
sir,
just came by
I'm gonna ask you to be quiet.
backside of Lowe's on the
Okay. What
My
else do you
path
think
looks
is
like
here?
they got a
And then you're
rear
gonna,
end NBA there.
In this closet. This is where we kept them.
I don't need her to do the
Five cans on the 510 at the Lowe's entrance.
get them.
Two boxes on the 510 by the Lowe's entrance.
Can I set these?
Got 10-4. I could tell, it looked like they were outside looking at the front of the rear end of the vehicle.
The CDs, I got
DVDs.
the, I got the, oh, they're downstairs.
Okay.
No, I had purchased on the 10th.
Maybe you might have one or two, but I'm telling, I've got the picture that we have as evidence.
Show in there, pick the ones you want, and if you, let 'em-
Like that is not.
did you buy any old ones at Christmas?
Those are $5. Yes, ma'am. Those are the best ones.
Series.
She's picking the ones she
We
wants.
have
No, these are ones I know.
a vehicle
Yeah,
in
we have those,
PA,
but you're
and
picking
then
No,
those.
she's not, she's not. She's just picking the ones right now that she knew was
But
right
I
here when you were.
had.
And if we have to, we'll sit here and let you pick one and let her pick one.
Correction, he was passing by a small vehicle.
Who gets to pick the first 12? Right?
Well, he did say
That's
there were
fair.
24 total, and he gave her 12.
I said I never do count them, sir. That's what I said.
But she says there are 12. She's gonna get out the ones that she says y'all had. So I want you to kind of watch her so you can disagree with any one of the ones that she had. I'm gonna let you pick the first 12, because she got 12.
May want to caution them on how much stuff she's taking if she has the capacity to take it out of here.
We did.
Okay.
That's far.
Like all of these and all of these are ones we had purchased that were here. All of the box series of The Walking Dead.
I posted the video to YouTube, the news media picked up on it, and the rest is history. This is my client's home. Your home is your castle. Your home is the most protected place there is under the Fourth Amendment of the Constitution. So that hits the internet. Judicial disciplinary charges come down against the judge. Ultimately, the West Virginia Supreme Court found that she had committed 13 different canons, or violated 13 different canons of judicial ethics, that she had performed an unlawful search of my client's house, and that in acting in that way, she wasn't acting in a judicial capacity, but rather in an executive capacity, which is a law enforcement capacity. So why is that important? Well, now we're in the civil lawsuit in federal court. Basically, a violation of the Fourth Amendment is the allegation, and the issue is over money damages. Now, similar to qualified immunity, judges can assert what's even better for them, judicial immunity, which is a form of absolute immunity that's almost impossible to get beyond. So that's why this case is important. That's why it's interesting. So we have a West Virginia Supreme Court decision saying that she searched my client's house, that was unlawful, and that was not even a judicial act that's allowed under the West Virginia Constitution and her state authorities. We're at the point now to where we've completed discovery. We're either headed to trial or we're going to lose on judicial immunity. So the federal court is going to have to make a decision here. But now, there's no doubt that this search was declared by the West Virginia Supreme Court to be unconstitutional, as an egregious abuse of process, a violation of the sanctity of my client's home, and I think they also called it a serious misconduct. Everyone involved has now testified that they don't care what the West Virginia Supreme Court says. Both of the bailiff and the former bailiff who were involved in this search testified during their deposition that really, they haven't had any policy changes, and The department authorized these sorts of judicial searches, and there has been no policy change. The longtime bailiff of this particular judge has testified that if she asked him to do it again today, he'd go and do it. And that's just outrageous. The highest court in the land has declared that judges don't search houses, which should be obvious, and that it was unconstitutional. Again, egregious abuse of process, serious misconduct. And now you have 2 active sworn law enforcement officers who are involved in this illegal search of my client's house saying that they don't really care what the Supreme Court says. They'll do it again. Now, all of this has been briefed, and it's been submitted to the federal court. The federal court will decide the immunity issues and let us know whether or not we get to go towards a jury trial. So just today, the federal court issued an order denying the judge's claim of judicial immunity, ordering that the jury trial is on. As the order acknowledged, the West Virginia Supreme Court already found that Judge Goldston's conduct was in violation of the law. Now, this opinion that's out today went on to address Judge Goldston's arguments that she was merely holding a family court hearing inside Mr. Gibson's home, and that she should be immune from liability. The court pointed out the obvious flaws in her argument, stating, quote, "The crux of Judge Goldston's argument is that her actions were taken during the course of adjudicating a family court dispute. She contends that, assuming she exceeded her authority, her actions were judicial in nature and hence subject to judicial immunity. As noted, the court examines the nature of the act and not the actor. The nature of the act was a warrantless search of Mr. Gibson's residence and a warrantless seizure of his property. Does a judge normally execute a search warrant on personally search a residence? To ask the question is pretty much to answer it. While the issuance of a search warrant is unquestionably a judicial act, the execution of a search warrant is not. Again, I'm reading from the court's order today. Judge Goldston was not engaged in an act normally performed by a judge. So where are we now? Well, we won the issue of judicial immunity. Just before the jury trial was set to begin, the defendant judge appealed the case to the Fourth Circuit. Since this matter involves judicial immunity, it's capable of being appealed prior to trial. Usually a defendant is required to wait until afterwards. They just filed their brief a couple of days ago. Next, it's our turn to file a response brief. Here's some great news. The Institute for Justice is joining the case since this issue is so important, and they're going to be doing what they do best. So our response brief is due in mid-November. I'm excited to have them on board, and I look forward to seeing what happens here. As always, thanks for watching, and you can find more detailed information on this at the blog post linked in the description at thecivilrightslawyer.com. The briefs will all get posted there as well. Make sure to subscribe for updates. Remember, freedom is scary. Deal with it. I'll see you next time.